up again. Our next presenter is Tameeka Williams. She's with the Legal Aid Society of Eastern Virginia, and she's with their Norfolk office. And she'll be speaking to you about consumer law, specifically what do you do when your client gets in trouble, dire financial straits and bankruptcy issues. So please give her a warm welcome.
Thank you for the warm welcome. So today we're going to talk about the collection-proof debtor. And I hope you all have your materials or was emailed to you. So I'm going to just kind of use my materials as a guide, kind of go through it. So to set a little background here, the collection-proof debtor, where are we? We're talking about when you have a creditor, JCPenney's, Visa, Discover, MasterCard, and you have a debtor. Your client, someone who owes money to Visa, Discover, whoever. And your client, the debtor, is sued in court, let's say $1,000 in general district court. And the creditor, MasterCard, Visa, Discover, has a judgment in hand, and now they want to collect the money owed to them. So your client may not know their rights, so you as an attorney are going to advise them of their rights, and so we want to talk about a specific debtor, the collection-proof debtor, who don't know they're collection-proof and worry about how am I going to pay my rent and all the other bills and still deal with these creditors that are coming after me, and I can't afford to file bankruptcy, I don't want to do that, I don't know what other options I have. I want to set forth this case hypothetical, which unfortunately is all too often the case, especially when we're looking at legal aid clients. But Edith, she's an elderly widow. She's all afraid and confused about her debts. Her only source of income is Social Security. So she found herself in a lot of debt after her husband passed away. She tried to make do and pay her medical debt so that her doctor will still see her. She skimps on her heating and cooling of her apartment. She rationed food and medicine. She has an old car but no longer drives because she has to save money. Edith is being harassed by creditors who threaten to throw her in jail and take most of her valuable possessions, including her family Bible. One collector told her that now that her husband's dead, she doesn't have to care for him any longer, so she can go out and get a job. She's humiliated. She can't sleep at night. She believes, oh, bankruptcy must be my only way out. I'm on a fixed income. I only get Social Security. What am I going to do? She calls legal aid. Legal aid is overwhelmed with requests for legal services. So we want to give her advice at least on how she should deal with this debt situation. So let's talk about, well, what are exempt income? What is exempt income and property? And here I set forth common sources of exempt property: Social Security, administration payments, veteran benefits, unemployment compensation, workers' compensation, and the statutes are set forth there for your looking up later. One thing important to know about Social Security benefits, that if they're deposited into a bank account, they will be protected generally up to 2 times the amount of the monthly Social Security funds deposited, okay, depending on the look-back period. And we're going to talk about what the look-back period is. So the bank must review the account history for the prior 2 months. That prior 2 months is called the look-back period, to see whether one or more federal benefits payments were directly deposited into that bank account. I want to go over what a look-back period looks like. So here on page 2, it says a financial institution receives a garnishment order, okay, on Wednesday, March 17th. That financial institution has to perform an account review that same day. They don't have to, but they do on that same day, that March 17th. The look-back period begins actually the day before, which is March 16th. That's the preceding day of the account review. So, and that look-back period is going to end on January 16th, 2 months prior or earlier. So, another look-back period, just to give another little example on when there's a weekend in between the receipt of a garnishment order and an account review. And this is going to prove important in the next example. So a financial institution receives a garnishment order on Friday, December 10th. And the financial institution performs an account review 2 days later on Tuesday, all right, December 14th. Well, that look-back period is going to, again, begin the day before on December 13th. and the look-back period is going to end on October 13th. So these look-back periods are important because when a client comes to you, you have to say, and they say, well, you know, my account was garnished. You want to determine, okay, what is protected and what's not protected in that account. And the bank is supposed to do this, but as we know, sometimes the bank mess up. So you have to take a look at that. Once we determine what period of time we're going to take a look at to see, well, what funds were deposited during this look-back period, we have to then determine what funds in that look-back period are going to be protected. All right? So, again, same thing. Edith, her Social Security income is deposited directly into her account, and the financial institution receives a garnishment order for $2,000, and that's on May 20th. So the date of the account review takes place that same day, May 20th. The balance in her account at that time is $1,000. So the bank gets a garnishment order, say we are entitled legally to $2,000. The bank, before they put a freeze or seize the account, they have to say, well, I need to take a look back at what's gone on in this account before we're able to determine whether we should freeze this account or seize these funds in the account. So the bank looks, says it's $1,000 in this account, and they look back for the look back period, May 19th. It goes all the way back to March 19th, and they determined that 2 deposits came in from federal funds. They're in the amount of $1,250 on April 30th, and then another $1,250 on April 1st. So, totaling $2,500. So the bank has then determined that $2,500 should be the protected amount because 2 deposits went in. It doesn't matter if money came out to pay rent or mortgage, other monies came in, maybe she had money given to her as a gift by a child, $50 or $100. It doesn't matter. They don't look at what went in and what came out. It's just automatically looking at what federal money went in, how much was it, total it together, and that is simply the protected amount. So, since $1,000 is in the account and $2,500 is protected, the $1,000 will be protected because it's less than $2,500. So, Edith doesn't have to worry about the creditor taking her money out of the bank account because it's federally protected money. She may not even know about it because the last statement there says that the bank account, the federal institution, does not have to even send her a notice about it. This wasn't always the case. Prior to 2011, we had clients coming in all the time. What had to happen was they would get their account, the bank would just seize the account. They would have to go down to the courthouse and file an exemption for exemption hearing, and they would have to wait 7 to 10 business days to get in there. And meanwhile, rent's due, et cetera. There's a lot of barriers and things that people have to overcome to just simply get their money back, where the law said it's exempt, but they didn't have this part in place where it put the responsibility and burden on the bank to say you have to take a look at that account before you just freeze it. So that way the people can avoid just coming to court to say, it's Social Security money in here. They can't take it. So that was great that happened. And so people who are already living at or below poverty don't endure that inconvenience of having just to show up in court to say this money is exempt. So that's a good thing. Next, another common source is wages. Certain wages under the amount of $290 a week after federal and state taxes and other things that mandatory things that have to come out like FICA are deducted. The amount of $290, anything $290 or less cannot be garnished. So MasterCard sued, the creditor sued the debtor, they want to try to collect, they can't get their bank account, they're trying to get their wages, all right? So we have to take a look. Someone shows up in your office, you have a pay stub with them. My wages are being garnished. The first thing is, well, should your wages be garnished by law? What does the law say on that? It says that if it's less than $290 a week after your taxes are taken out, then they can't garnish you. So you have to look at it and do an analysis. You have to deduct off if there's optional deductions. You know, they may have their car insurance or medical insurance coming out of their check. That's not a mandatory deduction, so that has to be added back in. Only the state and federal taxes and FICA are, after those are deducted from your gross income. Is it $290 or less? So, a judgment creditor may only garnish the smaller amount of this formula. The amounts by which the gross wages minus the amount that must be withheld by law exceed the $290 a week, or 25% of the gross wages minus the amount that must be withheld by law. So let's take a look at it in a practical setting. You have the client earns $300 a week, and that's common at legally. I know it sounds ridiculously low, but that might be the case. $300 a week. Well, let's examine that. And that's $300 after federal, state taxes are taken out. So that's their amount that they get after we determine that that's the appropriate amount, $300. So the amount that it exceeds $290 is just $10. However, 25% of $300 a week is $75. So the formula says the smaller of those two. So it's either going to be $10 or $75. The smaller is $10. The most that their check can be garnished is $10 a pay. So we, however, see a lot of times where clients come in and their employer do not know the law, and they have garnished them at some ridiculous rate. I had a client who came in and she was making $300 a week after the taxes were taken out, and her employer was taking half, 50%. And they did not know. They misread the garnishment summons and was taking literally 50% of a $300 a week check. So this client was trying to make it, pay her rent and everything, of $150 a week. Her employer was just simply wrong. So her recourse, you know, she doesn't know, she's called legal aid. So we look at the analysis, look at her pay stub and said, no, that is outrageous. She's not supposed to do that. Some employers automatically take 25%. $75 out of $300 versus $10, that's a substantial difference. So we have to understand the law, we have to be able to understand and be able to convey that to the client, and then of course educate any employer that does this to someone. So that is the analysis. So again, protected sources. If you have one of those sources of income from Social Security or one of the others that's listed there above, or if you're working a job where you're only getting paid $300 a week, it could be a part-time job, you know, whatever it is, this is the formula that's set forth to say you cannot garnish at that rate. And unfortunately, there are a lot of people out there being garnished at the wrong rate. So it may not even be a legally client. It may be another type of client that come in and say, my employer is just garnishing this amount of money. That's wrong. You're immediately able to correct it by contacting the employer, and then have income stream coming back into your client's household. And maybe in the long run, you know, bankruptcy might be an option, but if they can't do that right now for whatever reason, this is a way to kind of say, you know what, these incomes are protected and they can't do this. So the next thing I want to talk about is exempt property, and that's over on page 4. That's listed in the Code of Virginia, what is exempt, and it's just a list there, $5,000 worth of household goods, $1,000 worth of medical, $10,000 worth of tools and equipment you need for work or school, and you know the list goes on, and it's set forth where you can find this information in the code. But certain things are exempt because the next question is, well, can't they come and take my car? Or if it's, you know, of course it depends. But you know, if it's not secured, we'll talk about unsecured and secured debt in a minute. But they have up to $6,000 in equity in a motor vehicle that cannot be taken from them. So again, it's important to understand, you know, what income is exempt, what property is exempt, because generally people don't understand that. So after we get through making an analysis with Ms. Edith or any client for saying, hey, listen, we counsel with you, we understand the facts of your case, that you have Social Security, you can't do that. She's really, almost always clients are relieved, like, oh, they can't take on Social Security, because creditors will, debt collectors, as some of us may know, will tell them anything. You're going to go to jail, we're going to do this to you, that to you. So it's true. They get very worried about that. And by educating the client, they feel a big relief is lifted when they are educated about what their law is, what their rights are. So we also want to counsel them on just simply, okay, surviving debt. Right now, you can't afford to hire a bankruptcy attorney right now. Bankruptcy may not even be an option or something that you need to do. So what are we going to do about the debts the debt collectors call and harassing? First, you want to counsel and say, okay, you have to prioritize of debts, of course. And this other stuff seems basic, but people get so overwhelmed with they live in and trying to make ends meet when they're living on a fixed income, that a little counseling, when we're attorneys and counselors at law, so you got to put on a counselor hat sometimes and say, you know what, you pay your most important expenses first. Don't let a creditor tell you that, you need to pay us a set amount of money, enter into a payment plan, and we'll stop calling you. No, you have to pay your rent first, because what we'll see is, oh, well, I was paying $20 or $50 to this debt collector, kept calling me saying I needed to do this. So now I'm behind on my mortgage, on my rent. So now you've created an issue when you have an unsecured creditor asking for money when you need to pay your basic monthly living expenses. And so, but, I don't know what they're telling people in the air, but they really get people so riled up and scared that they just do things that are not practical, like not pay your mortgage or rent, and even sometimes go without utilities because they feel that they have to pay this debt. So what we tell clients is, you need to always pay, of course, your current and needed living expenses first. You have to keep the mortgage and rent current and utilities current and car payment current because they, want to keep the vehicle. They want that repossessed. Now I want to back up for a second on debts. Debts are either secured or unsecured, and you probably all remember that from law school where secured debt is where, the creditor has a claim on the property. A car note is on the car, so you don't own it right out. They can repossess that. Whereas unsecured debt, of course, the credit cards, hospital and medical bills are unsecured, where they can't necessarily take your property if it falls within those parameters that I set forth there. And so we do a little bit of counseling with them on that, but then the most important thing, what really helps clients out when they're in a position that they can fall where they can say, you know what, I can't pay this bill, and I don't want this debt collector to continue calling me. And under ceasing communications under 15 USC section 1692C, it states that if a consumer notifies a debt collector in writing that a consumer refuses to pay a debt or that the consumer wishes the debt collector to cease further communication with the consumer, the debt collector shall not communicate further with the consumer. And then there's an exception, of course, that they can notify them or advise them that the debt collector further efforts are being terminated. So they can say, okay, we won't call you anymore. So that's not going to violate the law. There's also an exception that they can notify the consumer that the debt collector or creditor may invoke specific remedies which are ordinarily invoked by such debt collector or creditor, and where applicable, of course, that the debt collector or creditor intends to invoke a specific remedy. So we have a sample letter that we allow, we actually give out to the client, and it's, if you turn to page 9, you'll see the letter set forth there, and I think it's worth pointing out that it states, your company has recently contacted me. Now the next sentence go on to say, I'm presently unable to pay anything because of my poverty, but that's not necessarily needed there. But it's there. They say I can't pay right now because of whatever the situation is. I'm going through a situation. But anyway, it sets forth the statute, and of course, if they fail to comply, there's maybe a fair debt collection violation that then can be pursued in court as well. And the last couple of points there, I was on this section, it says, of course they can't be arrested or jailed for not paying bills, and it's not a crime to not pay a debt or judgment. And that is unfortunately a really common misunderstanding, especially amongst the elderly population, when the debt collectors are calling them to say, you must pay, because they really do believe like that, oh, I have to go to court. I've never been to court before. Am I going to jail? And so we want to do that. I also want to just point out, and you guys are young professionals, we at Legal Aid have opportunities, of course, for you to come in if you want to volunteer to talk with some of the people that call us, because we cannot actually handle all of those calls that come in. So it's really important to do that. And with this information, you'll be able to. All right, so I have some more examples set forth here about the look-back period that's important, because it states here that generally up to 2 months, but there could be other periods of time that it could actually be more than 2 months of pay. So if you turn to page 7 with me, the example 2, where they have 3 benefit payments during the look-back period. And it talks about here that there is a financial institution, which of course is, a bank like we've been given an example of. They receive a garnishment order against the account holder for $8,000, all right? So a debtor owes a creditor $8,000. They perform an account review, and when they perform that account review, they see that the balance in the account is $5,000. So they look back over the preceding 2 months, which is December 1st, and it ends on October 1st. So the account review shows that there are 3 federal payments deposited, totaling $4,500. One of them was for $1,500 on December 1st. Another was for $1,500 on December 1st, and then another on November 1st, and there was a third on October 1st. So here we had 3 payments going during that time period. And then that totaled $4,500 for those 3 benefit payments, and it's less than the $5,000 account balance. So therefore, the protected amount of $4,500 remains, in the $500 overage amount is actually seized, all right, which is consistent with the state law. So the financial institution will then send a letter to the account holder saying that you have $4,500 available, but we will seize $500. Now, that money doesn't go directly to the creditor, of course, immediately. There must be a garnishment summons return date set at court, because it still gives the client an opportunity to invoke any other exemption benefits that are out there, and there are a number of them out there, and they're set forth in the statute, of course. And so, and that debtor also may, at that point, want to file for bankruptcy. So the bank isn't turning that money right over to the creditor, and that is a common misunderstanding as well. Just like when the wages come out of the weekly check or the bi-monthly income, that money isn't turned over to the creditor, although I will say that sometimes employers do make the mistake and not send it to the court for holding, but send it directly to the creditor. I've had cases like that, and that's been a mess, because there are exemptions that can be invoked. And then they'll say, oh, I'm sorry, I already sent it to the creditor. It's like, no, the garnishment summons says to send it to the court, because the court then can make it, then it allows the debtor to have opportunity to then exercise their right to file whatever exemption or bankruptcy if they want to do that. So that's an important point to set forth as well. If you guys have any questions, of course, oh, yes, I have a question.
What do you do with that exemption?
What I've had to do, because this has happened, I actually contact, there normally is if there's a lawyer on the other side, and you can tell by the garnishment summons, actually, it lists the attorney for the creditor. I will contact that attorney. If not, I contact the creditor. But I normally, in my case, I actually contacted the employer and said, you made a mistake. It's your responsibility to fix it. And they normally do. They normally feel really bad when they make that mistake, and they normally do. I had a client where she not only got her money back from the employer because they cut a separate check immediately and said, oh, it's our mistake. We're going to go ahead and give you that check back. But the creditor normally say, oh, they should know better, right? And say, no, I'm not supposed to get this money directly. It needs to go to the court. So that money is sent back to the court. And when I informed the employer, of course that money's going back to the court. Like, that's okay. She can keep it because it's our fault. We're sorry for the inconvenience. So that's the solution to that. A lot of it, of course, we can all run to court real fast, right? But a lot of times you want to go ahead and get on a line and get someone who's in charge, write a letter demanding that they fix the problem. And that usually can get done way faster than going to court to file an exemption claim. Because, of course, the statute says there that the court has 7 days, business days, to set an exemption hearing or set a hearing. So the first step is always to try to resolve it, of course, with the other party. And, if it can't resolve in a day, if you don't get a result a day or two, of course, and maybe simultaneously file something, of course, but at least get on the phone and see initially if you can get something going. If it sounds like they're going to be reasonable and fix the problem, then that avoids that appearance down there at court. So, but that's what I've done in the past. So, but yeah, unfortunately, it happens quite frequently. We have people, first thing I do when they say, oh, I'm being garnished at 25%, I have to take a look at the pay stub and say, well, where, is this the appropriate amount? And unfortunately, all too often, it's not the appropriate amount. And it's something that I can do right away is to contact the employer and say, listen, you're not doing the formula right. And you'll be shocked to hear, oh, well, we are not lawyers, we don't know. It's like, it's your responsibility to know. You're an employer. You have to know the law when it comes to wage garnishments and things. So yeah, that is all too common a problem. All right. And the 7 days. 7 business days. If that's not set, or the exemption? No, they have. What happens is, that's a very good question. Okay, because a lot of people, for whatever reason, may not get. There's a notice that and this is usually general district court. We're in general district court. They will get a copy of that garnishment summons sent to them, and they attach to it. The court's so helpful. They attach the exemption claim form listing all the possible exemptions. And someone who's even pro se might be savvy enough to look at it and say, oh, most times they do resort to trying to contact a lawyer and say, what are my exemptions? What can I do about this situation? And here's just an example of one way you could, but there's lots of other exemptions too that not fit in this hour. But anyway, when they get the summons, all right, say if they say, I don't know what to do, I don't understand this paperwork, I can't afford a lawyer, I'm trying to get the legal aid or whatever, they may not do anything. Well, remember when I said that the bank receives this order, they're not turning the money, like for example, in the example we just read, not that the $500 that's being seized, that actually is just being held there. It's up to the creditor, and there's normally like a 90-day period. They normally send out a garnishment, a lien, and say, okay, in 90 days, we'll return to court on this. So there's a court date set. It's normally 90 days out. So you don't have the client, if they don't do anything, and so within that, when they first get it, they don't have to do something in 7 days. They have to do something prior to the return date. That return date normally is set by the creditor, and it could be sometime up to 90 days in the future or more. A lot of times when people come to us, there's no court date set yet, and sometimes when they really should file a bankruptcy because they are garnishable. They do make well over $290 a week. And it's like the only way you're going to get out is you have a judgment against you, and you're not going to be able to afford this garnishment. You have to file bankruptcy. So they say, oh, they already captured money out of my checks, and the last check they captured money. They think it's just gone. But again, remember, I told you that it's really being sent to the court to wait to see what's going to happen. So it's just sitting at the court until the creditor either sets a return date and or the debtor files bankruptcy or files an exemption claim form and say, my money is exempt, or whatever the case may be, whatever exemption they choose to pick. So all isn't lost if they don't know when they first receive the form about the exemption hearing, which exemption they're entitled to. They're waiting to get in to see a lawyer. All is not being lost at that time. But my first question is, when I have a client come in, it's saying that they've been garnished, or their wages are being garnished, or there's a lien on their account, they can't access their funds. My first question is do you know if there's a court date pending? Did the creditor already set a court date? And sometimes if it's early enough in the process, they have not yet set a court date. It gives us time to do something, either an exemption or bankruptcy prior to that return date, because if you do something before the return date, the client can get that money back. If it's through a bankruptcy, it has to go through the trustee and all that good stuff, and that's a Chapter 7, of course. And then if it's through an exemption, then we also want to do something on or before that court date. After the court date, they lose that money. So a lot of clients are so elated, like, all this, sometimes things can go on for a couple of months, and they're like, they've been taking money from me. It's like, well, you understand that money is being held at court, waiting to see whether you're going to file an exemption or bankruptcy, or if the creditor is going to set a court date saying, release the funds to me, because they have not claimed an exemption or filed bankruptcy. So that's what's going on at that time. All right. Please, any questions, just feel free to chime in and raise your hand. So one other thing I want to point out under the looking at the financial institution who are receiving these garnishment orders was on page 8. Is example number 5. And it states here that the financial institution, and this is an example where you have an account co-owner with benefits. Of course, we get that in as well. But here, this example is about co-owner with benefit payments. So it says here that the financial institution receives a garnishment order against an account holder for $3,800 on March 22nd. The date of the account review is the same day, March 22nd. And the balance in the account is $7,000. So the amount the creditor says is owed to them is $3,800. Right now they have $7,000 in the account. The look-back period, that's the first step that the bank has to do. Say, well, let's take a look at the account. It's going to begin the day before, March 21st. And they're going to go back as far as January 21st. So the account review shows that 4 federal benefit payments were deposited into the account during that period, and the total is $7,000. So again, the creditor wants $3,800 to be seized. The account has $7,000 in it. The bank determines during the look-back period that there was a total of 4 federal benefit payments deposited, and they all total $7,000. So, but 2 of these benefit payments total $3,000, and that was made to the account holder against whom the garnishment order was issued. So 2 of the 4 payments totaled $3,000, and the payments came in for the person who allegedly owed this debt. Well, not allegedly, I guess they have a judgment against them, a valid judgment more than likely, but it's against the person who owes the debt, and so their money is $3,000. The other 2 payments totaling $4,000 were made to the co-owner of the account. Since the financial institution must perform the account review based only on the presence of benefit payments, without regard to a co-owner on the account or payments to multiple beneficiaries or under multiple programs, okay, the financial institution established the protected amount at $7,000, equal to the sum of the 4 benefit payments posted to the account during the look-back period. Since $7,000 is also the balance in the account at the time of the account review, there are no additional funds in the account which can be frozen. The financial institution is not required to send a notice to the account holder because there's no monies that are available to be frozen or seized at that time. So in this example, we see that when there is a co-owner of an account, it doesn't matter that the one who owed $3,800 had $3,000 to go in, right? And then at least $800, but they still cannot, regardless of how many account holders or how many different payments came in from different sources of protected money, irregardless, or they had to ignore that and go with the $7,000, which was the 4 payments totaled for both account holders, and so the funds in the account was exempt. So this is interesting to see how these different examples and different situations come up. And all of this can be found in the law that I cited, which is under this Code of Federal Regulation, and that is 31 CFR Section 212, and that's in Appendix C. So those are several illustrations, of course, and definition of the look-back period set forth there. Very interesting stuff. So, do I have any questions about that? Okay. All right. All right, so I think I'm good on time. Am I good on time? I'm good on time. A few more minutes. Okay, good. So let's take a look at another example if there's no questions, but interject the questions at any time. Back on page 7, example 4, benefit payments on the date of account review. A financial institution received a garnishment order against an account holder for $5,000 on Thursday, July 1st. Now, I've been using the term garnishment order for a little bit here in all these examples. I do want to point out that garnishment order pursuant to the definition set forth in the code in the CFR means a writ, an order, a notice, a summons, a judgment, levy, or a similar written instruction issued by a court, a state or a state agency, a municipality, a municipal corporation, or a state child enforcement agency, including a lien that arises by operation of law for overdue child support, or in order to freeze the assets in the account, all right, to effect a garnishment against a debtor. So I do want to point out that speaking of the child support and spousal support payments, Social Security can be garnished for those things, all right? So be careful with that, and that make sure you look at the exemptions that are set forth in the law about that exempt income, the ones that I set forth earlier, because there are a few exemptions there, and that includes the child support and spousal support payments. So back to example 4 on the payments on the date of the account review on page 7. So the garnishment order against the account holder arrives at the bank for $5,000, the amount of $5,000 on Thursday, July 1st. The date of the account review is the same day, July 1st, when the opening balance in the account is $3,000 and it reflects a federal benefit payment of $1,000 posted on that day. So here we have the account opening balance at $3,000, the federal payment of $1,000 posted on July 1st, and the creditor is looking to capture $5,000. The look-back period begins on Wednesday, June 30th. the date, okay, prior to the account review. And it's going to end on April 30th, that 2 months earlier. The account review shows that there was 2 federal benefit payments deposited during the look-back period that totaled $2,000. One for $1,000 on Friday, April 30th, and one for $1,000 on Tuesday, June 1st. Since the $2,000 sum of the 2 benefit payments posted to the account during that look-back period are less than the $3,000 in the account when the account review is performed, the financial institution established a protected amount of $2,000 and place a hold on the remaining $1,000. So you see how that happens? So even though I'm saying, okay, Social Security money is protected, it doesn't have to be the Social Security money in the account at the time, okay? It's just that this is the amount that's protected. So Social Security monies are protected, but also, say they won a scratch-off ticket, I'm at the lottery or something, and it was $3,000 that they put in there. $2,000 is still going to be protected. All right, so we understand that money is coming and going in and out the account, paying bills and things like that during these 2 months. So other money coming from some other source, again, could be the lottery, which is not exempt. All right, but it becomes exempt because it's in an account where federally deposited funds were put in. So I want to make that point clear. And that's in this example here set forth how that can play out. So again, the $3,000, they don't know where that came from. It just was there when they put that in there when the account opened. But the 2 payments that came in for $1,000 each total $2,000. So that account is protected. The $3,000, $2,000 protected. The $1,000 can be seized. All right. Again, it's going to be held in that account until 1, the creditor sets a court date and asks the court to have a garnishment summons sent over to the bank. The bank then sends $1,000 to the court. The creditor can show up to the court, and the debtor has a right to show up on that same day too, and have, if they have completed an exemption form or they have their lawyer there that have filed an exemption notice on the day or before the day of court, then they may have some other exemption to protect the $1,000. So exemptions can be layered. It can be from, that this is Social Security protected, and then there's other exemptions such as dependent children, a homestead deed, where back on earlier in my materials, where we have the list of personal property on page 4, exempt property on page 4 of section B. It states that up to $5,000 worth of additional property. So if a homestead deed is filed with the circuit court, and that's in the city in which that debtor lives. So there could be several exemptions and stacked on top to save money, but they would have to go to court to show up to try to save that $1,000 from being released to the creditor. And if it's a one-time thing where normally we don't keep that kind of money in my account, normally otherwise don't have other exempt income or property, then they may want to do the homestead deed in circuit court versus filing a bankruptcy to at least save that $1,000 and avoid going through the bankruptcy process. So there are ways to protect the other source of income. It could be income from child support, which again is exempt as well. So yes, I have a question. Normally, the NADA book, there's a statutory law that states that that's legally what we can look at. So there's NADA? Mm-hmm. Okay. Mm-hmm. So that's a good question. So yeah, they're set forth to let the $3,000 firearm. I do want to point out that if the householder, if your client is 65 years of age or older, that is, it jumps to $10,000 as the exempt amount. It was not exempt amount, but the amount that they can claim for just their property, general property, through a homestead deed filed in the circuit court. I do want to point out that it is a temporary fix. So if your client, we had clients, that say, I can't do a bankruptcy. Well, I normally don't have garnishable income. It just so happened that I received a lottery winning for, $500 and happen to put that in my account. Then I want to go ahead and use this as a way of getting that $500 back. But if it's just money that normally comes in their account and they're going to keep putting it in and it's not exempt monies, they don't want to use their homestead because it's a lifetime amount. Can't just keep using it over and over again. It's a lifetime amount of $10,000 if you're over 65 or older, and then $5,000, of course, if you're under that age. Which brings me to another point too, back to the exempt income. Okay, a lot of times people's money is direct deposit, of course, in their account. All right, so again, a creditor can try to garnish wages, and then the employer's responsibility is to determine how much, if any, can be garnished. But say that they didn't go through the employer route. They went to the bank account, and that money is direct deposited into the bank account from their wages, and they're making $290 a week after taxes and everything come out. That money is still going to be protected by law. Okay, so that's another point to make. Again, the $290 a week that they make in income, the creditor, they can send a garnishment to the employer, or they can go after the bank account. Just because your money is direct deposited into your account, you don't lose that exemption of the $290. They can't just say, oh, it's in the account, I can take the whole $290. No, it's still income from employment. And if you can see that, if the judge can see that from the bank statement, here's my check stub, this is the exact amount that went in, direct deposit to my account, then this is money from my job, and they can only garnish 25% of the money in there of this appropriate amount over the $290, or whatever's over $290, whichever is smaller. And they do have to show up to court to invoke that right and to state that. So that's a case to look out for as well. They don't lose that exemption just because the money didn't go directly from the employer to your client, but went from the employer into the client's bank account. So that's a good point to make there. Okay. Do I have any other questions? I think that we have met the time limit if we don't have any more questions. I think I'm the only thing standing between you and lunch. So if there are no other questions, I think we'll end my presentation there. Thank you so much for your attention and time.